I want to thank everybody for coming out today. I know we've talked a lot in the past about Chapter 7 bankruptcy, Chapter 13 bankruptcy, and I get this question a lot, like, well, bankruptcy is on the, is that guy walking with a pizza? Yes, he is. So the question I get a lot is, well, bankruptcy seems like it's on the extreme side of the financial equation. And so the way I explain this is that, yes, absolutely, bankruptcy should be a tool that is used to help folks when they're in a tight pinch. Now, before you get into that tight pinch, most consumers will end up with a mountain of credit card bills, and they start getting behind. And oftentimes what they'll do is they'll try to cherry pick. And what that means is they'll pay off some of the debts for some of the credit card bills, while the other ones that have high interest, those they just stop paying. And unfortunately, what ends up happening is very often the ones that they stop paying go to collections, and then they get passed to a law firm. And there's a bunch of law firms in the state of Florida that their entire role is to sue consumers in small claims and circuit civil type of cases. Small claims is going to be $8,000 or less, and the circuit civil are going to be over $8,000 in terms of dollar value. And almost every complaint that they file is exactly the same. Breach of contract, right? You agreed to pay something, and when you couldn't pay that something, you've breached that contract. And you've all learned contract law, shout out to Leacock, in terms of offer acceptance and performance. And so therefore, with that being said, when the debtor stops performing on their end of the contract, the credit card company ends up suing them. And so it's very often, well, somebody will call my office and say, listen, I'm getting sued for $7,500. So below the threshold for circuit civil, very easily accommodating within small claims court within Florida. And so that person really has three options. The first option is they could hire an attorney like me or you guys in the future to do what's called debt defense. And the way debt defense works is they hire you to essentially negotiate that debt as best as possible before the pretrial date. Because in the state of Florida, small claims cases have a pretrial date. And for cases that are not small claims, they'll have a hearing, but it'll be months from now. But your job at that point is to negotiate that debt as low as possible. So let's say it's, for numbers point of view, $10,000, right? In theory, if your client paid you $1,000 to negotiate that debt, you could very likely get it down to half. So debt started at $10,000, they hired you and paid you $1,000, you got it down to $5,000, their net cost came out to $6,000, because if you add in the $5,000 plus the $1,000, that's still a $4,000 savings that the consumer received. That is a win in my opinion. So today we're going to talk about credit card and loan defense and what it is and how it works. And so you've got creditors like American Express, Visa, MasterCard, and so on who are suing consumers through law firms. You also have personal loans that also, fall under this category. These predatory web loans, these cash advance types of loans. And so for those, it's the same concept in theory. Your client says, well, I don't want to file a bankruptcy because I don't have that much debt, but I do have this $10,000 credit card bill from American Express or Visa or MasterCard or whatever it is. And it then becomes your job, like I said earlier, to settle that as much as you can. Real story time, when I was in law school 2L year, I got sued by American Express. I'm pretty sure I was in this classroom in the third row when I found out. They served my apartment building, and the front desk receptionist accepted service. So I got sued by American Express for about $13,000. I also received a bunch of letters from different lawyers offering their services to me. And so I started calling all the lawyers and saying, listen, I don't know what to do. And there was this one nice lawyer, I'll never forget it. I forgot his name, but I'll never forget what he did to me. He said, Sahil, if you're going to become a lawyer, you need to settle that debt as fast as possible. And so I called American Express and I said, American Express, I'm a law student. I can't afford to pay all this at one time. Please help me figure this out. And prior to coming to law school, I had built .com companies and made lots of money and spent lots of money on stupid things and stupid people. We've all been there. I'm looking at some of you right now. You're raising your eyebrows because I'm sure you've been in those shoes too. But the point is, we've all made mistakes, and I'm no different. So when I got sued by American Express, this lawyer told me settle the debt. I called American Express. We ended up settling for $6,000, so a little bit less than half. I paid it, and the reason I bring that up now is because when you attorneys, future attorneys, apply for character and fitness, you're going to have to mention your debts. And if you didn't pay it, it's going to bite you. And it bit me for other debts that I had, IRS debts, but that's a whole different conversation that we can have in our character and fitness class later on. So back to my story. You're getting sued, your client's getting sued, your job is to negotiate that debt as much, or I should say as low as possible, to give your client a net win. That is what debt defense is. So that's option one. Option two is they could always consider filing a bankruptcy. And the way I look at it and the way I tell my clients in terms of bankruptcy is that if you've got $20,000 in debt, and if you settle the debt, best case scenario, you're going to pay about half. So you take 20 grand, you cut it in half, that's still $10,000 that you've paid. On the flip side of it, the no-look fee in the state of Florida is $2,500 for a Chapter 7 bankruptcy if you qualify, plus the filing fee. So even if you went to an attorney, and again, this is option two, that charges you $2,500 plus the filing fee of $338, your net cost is still cheaper to file the bankruptcy than it is to settle the debt. The credit recovery is almost the same. The damage to your credit is almost the same. Long term, yes, bankruptcy will affect you more than that debt does. But if your credit is already bad, then I'm looking at you. So the reality of it is that oftentimes bankruptcy is the cheapest and the fastest option. But if you have to go the other route, then option one is your route. Option two is the bankruptcy. Option three, consent judgment or accept a judgment. And what that means is that you get sued, you do nothing, you don't go to the hearing, you don't hire an attorney or whatever it is. You end up losing, you get a judgment, and then the creditor will try to garnish your wages, levy your bank account, or figure out another asset to go after. And I'll explain all three. Garnish your wages, they'll contact your employer and say, hey, give us a portion of that money that this person is making. Now, if you qualify, there are certain exemptions in the state of Florida that prevent a creditor from taking that money from you, but that's if you qualify. Now, option two, which was the levy, which is where they go into your bank account and just literally take the money. I've had clients call my office and say, Sahil, I woke up this morning, my account is negative $40,000. When we start talking about it, we realize that they got sued a couple of years ago and there was a judgment floating around that they did nothing about. And now that judgment has come back to bite them. And then the third option that we talked about was going after other assets. Now, if you've got a collectible, or let's say a collectible vehicle, or if you've got an investment property or an investment piece of land, in theory, if it doesn't qualify for a certain type of exemption in terms of protection in the state of Florida, and we talked about this earlier in the previous class, and I'm talking about homestead protection, if it doesn't qualify for that, in theory, the creditor could attach a lien on that property. That is the third option that the creditor has. Most creditors, they're not going to tell you this, but most creditors would prefer to get a judgment against you. And the reason is because that judgment lives in the state of Florida for a long, long time, and it continues to collect interest. Last time I checked it, it was like 8.25 or 8.5 something percent interest is what they're charging. It's between 8 and 9%. Think about that. A good friend of mine many, many years ago, who's from New Jersey, now in Florida, had told me the rule of 72. And what that means is that if you have a debt, and if your interest rate is 7.2%, every 10 years that debt doubles. Now think of it this way. If your client has a judgment, and that judgment is $10,000, and the interest rate is between 8 and 9%, in 10 years, that judgment has now turned into $20,000. Creditors want that. They want to get a judgment against you. And the reason is because these companies are perpetual beings. They can wait 5 years or 10 years or 20 years to get their money. Now think about that. I said 20 years. That debt went from $10,000 to $20,000 at an interest rate of 7.2% in 10 years. Well, now that $20,000 turned into $40,000 in 10 more years. Is the creditor going to get that money? Probably not, but it's a gamble, right? The house always wins. So the way it works is you probably won't understand what I'm going to say next, but I'm going to say it anyway. I know you guys, most of you guys are 2Ls, some of you are 3Ls, but the reality of it is that I'm going to talk about certain specific documents that get filed with the court. Your employer will teach you this, so if at any point it gets confusing, you can email me, you can call me, you can raise your hand at the end, and I'll be happy to explain. But the detailed mechanics of how it works are very straightforward and simple. I know I say that because I've been practicing for a bit, but and I know this is going to be a foreign for you guys, but here's how it goes. Your client hires you, signs a fee agreement, because we do flat fees. Remember, fee agreement is for flat fees. Retainers are for traditional retainers. Florida Bar is very clear about this. Now, so we do flat fees. We charge our clients anywhere between $750 to $1,500, depending on the type of debt they have. And when it comes to businesses, we're actually on the much higher end of that. But again, it depends on the complex nature of the case. So client signs the fee agreement, client pays a down payment or the full payment and sets up a payment plan. So all that is done on the administration side. Next thing we do is we file 3 documents with the court. And that is assumed that our client has been served. Remember, until they're served, at this point, the lawsuit is just sitting in the system. The rules of civil procedure are very, very clear. Your client has to get served. The client has to get served. The defendants have to get served, or else the lawsuit itself just sits around. So, assuming our client has gotten served, assuming the client has paid us, assuming the client has signed a representation agreement, fee agreement, retainer, whatever you want to call it, depending on the mechanics of your billing, we'll file 3 documents. The first document is a notice of appearance. Does anybody know what that is? Everybody's looking at me like I'm crazy. Notice of appearance is a document that you're filing formally saying that I, as the attorney, am representing this client or clients on this matter. Now, you're supposed to serve that to the opposing counsel as well, and in some cases you want to serve it to anybody else that might be interested. Florida's amazing. We've got e-files, so everything gets served electronically. That's the first document, notice of appearance. Second document is the designation of email. We're in 2025, 2026. Well, we're in 2026 now, but we're in 2026. Nobody wants to push letters back and forth. So we're formally telling the court that we would prefer to communicate via email. So we file what's called a designation of email. And I know you guys are looking at me like I'm crazy, but it's literally a 1-page document that says that I am the attorney of record and this is my email address. And then you also serve that to the other side. Again, Florida has an amazing e-file system, so that stuff gets electronically sent to the opposing counsel. The third document, and in my opinion, this is the most important document. This document is called an answer. You are admitting, denying, or denying because you don't know the allegations that have been made against your client. Now, that is going to stop that 20-day clock in terms of service. You guys are looking at me like I'm crazy. In the state of Florida, after the defendant has been served, the defendant has to file an answer within 20 days. If they don't file an answer within 20 days, the plaintiff, the folks who are bringing the action, could in theory ask for a default judgment. My firm has done them. You know, we've asked for defaults in highly a-hole-ish types of cases. I mean, it happens. But the point is that you don't want that to be your client. And so you want to file an answer. And the answer, again, is going to be either admitting the allegations, denying the allegations, or denying because you don't know those allegations. You want to keep it as simple as possible, straightforward as possible. The way we do it is we just include 1-line sentences in our responses. You can go online and look at the Orange County Clerk's website, Osceola County Clerk's website, and just look up these sample documents. They have plenty of pleadings that have been filed over the last couple of years. So those 3 documents is what we file. The next thing we do is we, as a courtesy, email all 3 documents in PDF format to opposing counsel, along with a short note saying, hey, my client would like to settle. If your client has given you permission to settle, then you offer a settlement amount. And here's how that works. Let's say your client is being sued for $10,000. You file those 3 documents, notice of appearance, designation of email, and an answer. Once you filed all 3 of those documents, you put everything into a nice PDF, you send it to opposing counsel, and what we do is we'll say, our client has given us permission to settle this matter for X amount of dollars over an X amount of payment terms. Obviously, you need permission from your client. So we get permission from our client on the get-go. We then send it in to the opposing counsel, and the opposing counsel will either say, yes, we'll accept it, no, and counter, or no, and we want to fight this out because we want everything. Now, it's very rare that they go through the third option. It's very common where they will counter offer. Now, at that point, it becomes negotiation, right? If they're asking for $10,000 in the lawsuit, your client's offering $5,000 and they counter at $9,500, well, then it becomes your job to ask your client if they're willing to accept that or if they'd like to negotiate it further. Now, once the negotiations are done, it is your job as an attorney to ask for what's called a stipulation. A stipulation is just a fancy way of saying a formal agreement saying that the parties have agreed to the settlement, and then it becomes your job to review it, have your client sign it, and send it to opposing counsel so that it can get filed at the court, and then that case can get dismissed. Oftentimes, opposing counsel will put into their stipulation agreement that if your client misses a payment or doesn't make the payments as agreed to, they will automatically go to the court and ask for a default. That is a risk that you have to take with your client, but you have to notify your client up front that if they do not abide by the terms of the stipulation or the settlement agreement, that they could get in trouble financially. Now, if all else fails and the other side is not willing to negotiate, your client can't come up with the money to meet at the middle ground, you always have the option to file a Chapter 7 or 13 bankruptcy. Again, the fail-safe is always, in my opinion, the Chapter 7 or Chapter 13 bankruptcy. But we try to negotiate as best as we can, as long as we can. And oftentimes we can buy our clients enough time before they have to make their first payment so that they can catch up. If the client is being asked to pay $10,000 today and we settled their debt for $5,000, but it took us 3 months to get to that $5,000, well, we saved our client a bunch of money and we bought them 3 months of time. That's a win-win for everybody. Well, at least for our client, right? All right, vehicle deficiency. This is an interesting one. This is, in my opinion, my favorite one. And I'll explain what this means and the mechanics behind it. Vehicle deficiency means that you have a vehicle that was either repossessed voluntarily or involuntarily. Voluntarily meaning that you called the bank and said, hey, I can't afford this Ford Mustang anymore, please come pick it up, or I'll come drop it off. Or you're saying, I can't afford this car, I don't want to pay for it, but I still want to drive it around in the middle of the night, the repo man comes and takes your vehicle. Well, if that happens, what usually ends up occurring is the bank will then auction off that vehicle. Ford Mustang, I'm just using because it used to be one of my favorite cars when I was a kid. They will then auction that vehicle off. Let's say the car is auctioned off for $15,000, but you promised to pay $30,000. Well, that creditor still has the option to come back and sue you for the deficiency, that remaining $15,000. So oftentimes you'll get a phone call from a client saying, hey, I returned my car, why am I still getting sued for it? Well, it's your job to explain to that potential client, because this usually happens during the consultation period, that, sir or ma'am, you purchased a vehicle, you signed an agreement, you didn't abide by the agreement, the asset, in this case that vehicle, was sold for significantly less than what you promised to pay. Now that bank has the option to come after you. I actually did a consult just this morning before this class on that. And so then it becomes a situation where, just like debt defense that we talked about earlier, your job is to file 3 documents with the court, assuming that it's already in court, and then try to negotiate as best as you can. Oftentimes, you will get the best bang for your buck by negotiating early when it comes to these vehicle deficiency lawsuits. I'll go into this a little bit more in detail because I know everybody's looking at me like I'm crazy. You bought a Tesla, $60,000 Tesla. You paid for it for 2 years, loan was for 5 years. 2 years in, you can't pay for it anymore, the vehicle gets repossessed. You still owe $40,000 on that vehicle. Tesla, or whoever the creditor is, takes that vehicle, repossesses it, auctions it off for $22,000. Well, there's still a balance remaining. And if my math is correct, it's $18,000. Tesla, or whoever that finance company is, still has the option to come back after you for that remaining balance. And oftentimes they will. Remember, this is business, right? So the creditor will come after you for that money. You, as a consumer, hire an attorney to negotiate that debt. And if you, as a consumer, have your attorney negotiate it down to, let's say, half, $9,000, it's still a win. But again, you always have the option to file a bankruptcy. That's what I want to drill into everybody's head here. In my opinion, bankruptcy might be the strongest tool that consumers have when it comes to the legal playing field. And I'll say that again differently. The strongest tool that consumers have when it comes to fighting financial distress oftentimes is going to be bankruptcy. Think about that. I see a lot of you nodding your heads because maybe you've been through it, maybe you have friends or family that have been through it, but when your consumer client files that bankruptcy, oftentimes it's this stress that's been relieved off their shoulders. I spoke with a gentleman this morning right before I came to this class, and he said, Attorney Patel, he has a hard time saying my first name, Sahil, and he said, thank you very much, I was finally able to get some sleep last night. And that's because he came in with $50,000 in unsecured debt. He qualifies for a standard Chapter 7. We filed him a standard Chapter 7. And assuming that our 341 goes without a glitch, he's going to get that discharged. $50,000 gone in a matter of months, and he can start fresh again. So think about that. That is the strongest tool that your client has. It literally is.